Okay, well, good evening, everybody. Thank you so much for joining us for our first evening seminar of this term and for braving the aftermath of Storm Ciara as well. Well done, everyone. I'm glad we've all pulled through. My name is Norani Lidjon and I'm Director of the Information Law and Policy Centre. I expect that some of you, because I see some familiar faces, may already be signed up to our mailing list, but if you are not, please do. And we also have a Twitter account that you can follow us on as well for more updates. And for those of you already following us, you may have seen some comments and tweets about a lunchtime seminar we had today already on AI and the policing sector. But for now, it is my very great pleasure to introduce our interdisciplinary expert panel for this evening on the topic of digital justice. Our first speaker is Dr. Judith Townend. Judith is Senior Lecturer in Media and Information Law at the University of Sussex. She is also Community Engagement Lead at the School of Law, Politics and Sociology at Sussex and Deputy Director of the Sussex Centre for Information Governance Research. She's a socio-legal researcher and her publications and research specialise in freedom of expression and access to information. Our second speaker this evening is Gill Phillips, over here on our far left. Gill is Director of Editorial Legal Services at Guardian News and Media, publishers of The Guardian and Observer newspapers and TheGuardian.com. Gill qualified as a solicitor in 1984 and joined the BBC as an in-house lawyer in 1987. She's worked subsequently for News Group's newspapers and Times newspapers. She advises on a range of content-related legal matters, including defamation, privacy, contempt of court, and reporting restrictions. And Gill has also advised Guardian News Limited on phone hacking WikiLeaks, the Leveson inquiry, the NSA leaks from Edward Snowden, and HSBC files. Our third panellist this evening is Dr. Kate Leader. Kate is lecturer in law at the University of York, and her primary area of research is people who represent themselves in court. She has also conducted research in socio-legal studies more broadly, as well as criminal and international criminal justice. Last but not at all least, our discussant for this evening's panel is Penelope Gibbs. Penelope is Director of Transform Justice, a national charity campaigning for a fairer, more humane, more open and effective justice system, and visiting fellow at Kellogg College at the University of Oxford. And as you'll see from our original programme, two of our panellists were unable to join us this evening and they send their apologies. In terms of the format for our seminar, each speaker will present for approximately 10 minutes, and then we will open up the floor to discussion for Q&A. As you may have spotted at the back of the room, we have a wine reception afterwards, which I hope you can all stay and join us for. So I'd like to thank our speakers and for you for joining us here this evening, and we'll now invite you to begin our seminar on digital justice, convenience at what cost.
Thank you. Thank you very much. It's a real pleasure to be here, despite all the things that tried to get in the way of this event happening. We're finally together. So I thought I'd start by, it's probably stating the obvious, but just to emphasise the sort of scale of the court modernisation project. It's obviously enormous, and it's across so many different court and tribunal types, which all have their own particular practices, their own particular ways of doing things, and impacting a real variety and a very diverse group of users, with very many different needs. So I think there's probably very few people that could claim a sort of a total holistic expertise across that whole programme of reform, but what there are lots of people that know a lot about, about how a particular bit works. And so those of us that are sort of following and sort of critical observers of what's going on, I suppose most of us have a sort of special interest in a slice of the project, and that's certainly sort of the position that I'm in. So I thought I'd probably just explain a little bit of my interest, in particular the things that I've been following around justice reform, and how I ended up with that interest. So my sort of preoccupation is with the data aspects of justice reform and the data that's generated by the process of justice, and how that data should be used for both internal processes within and between the judiciary, court service and Ministry of Justice, and also in external processes, so where that data then is shared with public audiences, including members of the media, for the purposes of open justice, access to justice, for transparency. in doing this work around courts data, the question always comes up, what do we mean by court and justice data? So I use it quite broadly. I'm thinking about any information that's generated by the system, whether for quantitative or qualitative use. So that could be discrete pieces of information that are going to be used for statistical analysis, but also the sort of complex qualitative contents of documents like judgments. I sort of see that as part of the court data set as well. And why I ended up being preoccupied by this is probably a good question, but I think my professional life started in journalism, and I think initially I had quite a rigid, almost black and white view about open justice and about the public's relationship with the court process, and started to think about this question of how that should be done as we move into more digital systems. And I've then ended up pursuing socio-legal research sort of on this ongoing journey, and I think it has become more complicated to me the further I've gone along with it, as is the way with research. And talking to different user groups, I've sort of come across ethical, legal conundrums in terms of how the public does access and observes justice. And so it's all feeling a bit more grey and murky these days than when I started out. So in about, I think 2011, I had sort of took up this idea of what justice should look like in the digital era. I think Jill might be been involved in some of those discussions all that time ago. And that was really sparked by my position as a sort of outsider to the legal system, my dismay at how difficult it was to access the basic data to which actually journalists and the public were entitled to access. You had legal entitlements to access this data, but there were these problems in actually doing it. And part of that were just very practical things. It was that the data wasn't being collected in systematic formats, and that when it is, it's actually often controlled by private companies with a great commercial interest in preserving the control of that data, and they charge huge prices for data access. And that's obviously going a few years back when I started looking at this, but the picture hasn't really changed that much since. Just to give you one example, so at the time, around that time, I was trying to do some very simple analysis of defamation cases, and there's data that were connected to the cases, like the particulars of claim, was technically public under the civil procedure rules. So I thought, well, great, I'll be able to access these court documents. But the cost and the time involved in actually trying to get that data made the research completely impossible from a practical perspective. And even the MOJ itself was struggling to access the data it needed when it was looking at the impact of upcoming defamation reform. So they ludicrously, in one of their impact assessments, appeared to estimate the number of trials that had taken place in a given year, which, that was the most public event you can imagine in a court setting, sort of that we didn't have reliable data on this, I thought was just, but so bizarre. And then it struck me that if I was experiencing that in my little pocket of research at the time, then that must be the case in other areas of justice research, the justice system as well. And the more I've learned in the following years, the more I've seen that to be the case. So, for example, in the area of family law, I've been quite involved in a charity called the Transparency Project, which works primarily on enhancing transparency around family cases in the Court of Protection. And these cases have often, and I think sometimes unfairly, been characterised as secret proceedings, but certainly subject to a lot of misinformation and a lot of misunderstanding, which was partly fuelled by the lack of access to information about proceedings. I think there's been great strides in the family courts, and it's a much better picture than previously. And there's an ongoing transparency pilot and review at the moment, which is open to public consultation, which I think can only be a good thing. So that's family, then criminal, and Penelope is the expert in the room on sort of the criminal justice reform side of things. If she hadn't been on the panel, I would have been acknowledging greatly her work, because I've learnt so much from her. She's done so much in digging out the detail in terms of criminal justice reform, insofar as it can be found. Looking at the impacts of the criminal justice system on different user groups, I think highlighting user groups that have been overlooked, for example, the perspective of defendants, and thinking about how changes to the system are going to impact them, and looking at the potential implications of reform. So I thought I'd just, I want to say that I'm not sort of anti the court reform agenda at all. I think it's a sort of a necessary thing that has to happen. Obviously we need to incorporate digital technology to make justice more effective and fair. It's just questioning, I think, and it's really important to have a set of critical observers that are questioning the way it's being done, and trying to make suggestions for how it might be done better. So I've got sort of 4 things that I've just thought of in terms of what I would ask to the judiciary and to the MOJ and HMCTS in terms of focusing on the justice data as they develop new digital means of delivering justice. And I feel like a bit of a broken record of this. I mean, the things I have written around this area, I feel like I just keep making the same points, but I'll make them again tonight. Sorry if I'm boring anyone. But I think, number 1, it's really essential that they speak to a wide range of user groups and stakeholders. So in terms of my own experience around open justice, obviously a focus has been the mainstream media and traditional media groups, and that's perfectly understandable. The media plays a vital and central role in that whole open justice process, but they're not the only people that are involved in public observation of justice and the way that we might think about delivering open justice in the future. So I think that process needs to be opened up to involve other sorts of players, NGOs, academic experts. So the HMCTS Open Justice Working Group should include those sorts of people as well, I think. My second ask is that there should be independent, robust research to inform the development of policies that considers the side effects and implications of planned digital reforms on all types of court user groups, especially those that are most vulnerable. Obviously there has been work in-house and some research, but it hasn't always been wholly transparent, and I don't think there's a sufficient level of detail on the research that's being conducted, and Penelope might have more to say on that. And where possible, I think these institutions need to be supporting the work of independent academics. Obviously I've got a slight self-interest here, but I do think we play an important role. And there's so many expert third sector organisations who've been working with these user groups over decades who have got so much to contribute. I'm not suggesting that MOJ and HMCTS haven't done any engagement, but it's just thinking about how it might be better utilised as we go forward with court reform. Number 3 is proper open public consultation on significant proposed changes to the functioning of justice systems. So lots of the things that are happening haven't actually required primary legislation, and that obviously, if it does, then that does at least force some kind of public scrutiny process. But there's also things that are happening a bit more quietly, and then there's not always the opportunity for these experts that I've mentioned or ordinary court users to respond and to comment on what's being proposed. And on the open justice question, there just hasn't been any substantial public consultation as yet. When I've responded to some of the consultations there have been, I've had to sort of shoehorn in my own question because it isn't in the form, and so I think you should be asking this and thinking about this. So I've sort of been pushing on the open justice side that we need a better public consultation. I know that consultation processes can be flawed, that sometimes they can delay or obfuscate, but I do think, maybe I'm being naive, but I think that open public consultation is really important, and that we need to allow for that opportunity of hearing from voices that may be otherwise overlooked. And then finally, I haven't really developed this idea, so people can tell me that it's just completely daft and haven't thought it through properly. But I was just thinking, in the way that for terrorism law we have an independent reviewer with statutory powers to sort of review what's going on and to provide something completely independent of the system, put reports into the public domain, provide another means of accountability. So I was just thinking, what's missing to me at the moment in the kind of the accountability picture is having some form of independent reviewer of justice reform that would be able to go to independent academic experts, different kind of stakeholders, and sort of scrutinise what's going on. We obviously have parliamentary committees that have been doing significant work, but it would provide another means and level of accountability. So,
Fantastic. Steve? Yeah.
Thank you. So I suspect I'm now going to be the exponent of what Jude described as the rigid black and white view as an advocate of Article 10. So that may or may not prove more or less popular. Look, I thought I'd just start with some of the basics from my perspective, because I find it quite useful to go back. So, the importance of the open justice principle, long recognised, but some of the reasons for it bear some useful contribution, I think, to the discussion. So, a case involving the BBC in 2015, it is a principle at the heart of our system of justice and vital to the rule of law. And in the Guardian News and Media case, which was one that we bought, where we couldn't get access to documents in an extradition case, the court said that it promotes the rule of law by letting in the light and allowing the public to scrutinise the workings of the law for better or for worse. And there are lots of other sound bites in cases and in philosophy over the years. Bentham, obviously. Most recently, I guess, Lord Sumption in the Cuja against Times newspapers case in 2017, where he said the significance of open justice has, if anything, increased in an age which attaches growing importance to the public accountability of public officers and institutions and to the availability of information about the performance of their functions. And I think it's also useful to look at what some of the reasons are why people think open justice is important, because we sort of start often at that level, but I mean, and these are just some of the reasons that other people have written about, more cleverer than me. Open justice protects public confidence. It reaffirms the social contract by which any community must continually abide in order to function effectively. If the rationale for judicial decisions is left secret and justice is not perceived to be open public confidence in the system is consequently undermined, and individuals may be more inclined to take justice into their own hands. An insistence on openness can counter or neutralise any suggestion of secrecy or cover-up in the proceedings. That's a statement from an inquiry into the death of an individual by the police, Azelle Rodney, and another inquiry, Thames Safety Inquiry. It is of great importance that members of the public should feel confident that a searching investigation has been held, that nothing has been swept under the carpet, and that no punches have been pulled. And in that context, it also safeguards equality before the law. So knowing the identity of the parties, knowing the identity of witnesses, people can be assured or reassured that power, wealth or fame doesn't afford them special privileges through the justice system. And as Tom Bingham said, there should not be one law for the rich and another for the poor. So there are some very important sort of justice issues behind it. It also plays a really important role in educating members of the public about the court system. And Jude's touched on some of the aspects of the court system. For many people, particularly, I think family courts will be one of their main experiences of the justice system. And it is one of those courts where the state, in the manifestation of local authorities, particularly taking children into care, has a really burdensome role in something that can really impact on individuals. And so having a system that allows you and the public to properly understand and appreciate how it works and why it may work against them sometimes is very important. So the educational role that you get from open justice, again, is something to emphasise, not least because the declines in legal aid mean, and I saw some stats, the number of people accessing legal aid fell by 82% between 2010 and 2018. Almost, I never know whether this is a billion or 1,000 million, but 950 million anyway, sliced from the total legal aid budget since 2010. So, the number of people arriving in courts with no information, no legal representation is growing. And so the educational role that open justice and reporting plays is becoming more important. It also ensures that judges remain accountable for their actions. Bentham said open justice keeps the judge himself while trying under trial by compelling judges to justify their reasoning as a result of their publication of decisions. And I think that's one of the big changes we've seen through the family courts in the last 10 years. There's been a succession of family court presidents, starting with Sir Nicholas Wall, going through James Mumby to the present president, who've all realised that the family courts do need to be more open, and that there is a balance to be struck between that openness and protecting the privacy of those people who are before it. And I think another thing that slightly worries me, if everything goes digital and happens without real people being seen, is a sort of diversity of the judiciary as well. I sort of think, if it's just Judge X who's on some sort of stalk box thing somewhere, it's very easy then to lose. I mean, one of the issues at the moment is the fact that the visibility of the judiciary shows us that they're not very diverse. So, I worry about that. There one other thing to emphasise, I guess, around the administration of justice is that open justice offers a check on dishonest witnesses. It arguably enhances the quality of their testimony if people know that people can listen to them, can find out what they've said. It ensures that they're less likely to exaggerate. And we're all aware of cases like Stuart Hall where witnesses have apparently come forward when cases are made public. So, there are a lot of reasons, and when you feed those reasons into the sort of the digitalisation of justice, a lot of them start to become quite worrying, because they become much harder, I think, to deliver. And there's a slight glibness about some of the Ministry of Justice's consultations around this. They sort of say, yes, of course, we're aware of open justice, but I'm not convinced that I've seen practically a lot of sort of, we've really thought about it and this is what we're going to do. And I think that, you'll all be aware, no doubt, Article 6 of the European Convention, which affirms the importance of open justice, also accepts that there are limitations. It's a qualified right, and that open justice qualified right works together with Article 8 on privacy, if we're talking about the European Convention, and Article 10. And there's a sort of, there's a triangulation between them that has to be done. And there is a symbiotic relationship, there is no doubt, particularly between the press and Article 6. Article 6 open court cases have long been a source of media information and stories. And there's a balance to be struck between telling the stories of open justice and it becoming a sort of entertainment value show, which I think is one that is of concern to people. But in terms of the role of the media in the open justice principle, again, there's a lot of jurisprudence around this, but the right of the press to know, the right of the public to know, depends upon the press right to report. And the press are the watchdogs of the public, and so may report everything that takes place in open court. And they've been given quite a lot of privilege around that role. In Cuja, the Supreme Court said it has been recognised for many years that press reporting of legal proceedings is an extension of the concept of open justice and is inseparable from it. In reporting what has been said and done at a public trial, the media serve as the eyes and ears of a wider public, which would be absolutely entitled to attend, but for purely practical reasons cannot do so. So the media do have a recognised role to play in this, and in practice that's manifest by the basic starting point for most courts, which is that trials should be conducted and judgments given in public. And following on from that, there are the ancillary rights of the media to report those judgments, and that involves physical access to the courts so that you can observe, in certain situations, the right to report, and increasingly importantly, the access to a wide range of documents and information that is given out during hearings. And one of the difficulties at the moment, and we're in a sort of pre-main digitalisation stage, is it's already really difficult to get documents, and an awful lot of cases are done on the nod of the documents. Has everybody seen this? Written statements are taken as read. So even if you're just accepting that the media need to report fairly and accurately what goes on, that of itself is becoming increasingly difficult. And if you feed that into a scenario where there is less and less, and there's probably going to be less and less oral evidence and oral argument, how do you deal with that? How do you deal with that going forward? and put into that the fact that already the media don't have enough money to go to court all the time, whether you're looking at the local press or the national press. Louise Tickle, who is a great advocate of the transparency in the family courts, has recently just issued a crowdfunding page to get money to report on open justice in the family courts. I can't afford to keep trying to hold the state to account for how it exercises its power in the family court, she said. So, that leaves me with a lot of practical concerns arising out of the digitalisation of justice. How do you find out about cases? It's already really difficult to find out about cases. Listing is very poor. Quite often it's done with initials. Quite often it's done with no indication of what the case might be about. Courts are completely inconsistent with how they list and where they list. And some are very resistant to giving out any information at all. It's piecemeal, inconsistent and inadequate, but at least if a journalist is in the Royal Courts of Justice or the Old Bailey, they can go round the courtrooms and see what's going on. If that isn't going to be available, there's an awful lot more potential for things to happen without anybody being there to view it as a sort of independent arbiter. And as I said earlier, it's really difficult to get information at the moment. It's really difficult to get documents. How is that going to be facilitated? How are the media going to be able to interact in a trial process? At the moment, there's a public gallery, there's a press bench. They can pass up a note to the clerk or to the judge to say, I didn't understand this, what was that, who's that? How all these sorts of just purely practical issues about how the press are going to be able to find out and report about things just in the way of fulfilling their public function. So I'm going to leave me there at that point, and no doubt people can shout at me later.
Thanks, Gil. Kate?
Thanks. Actually, I'm taking a bit of a swerve, but in some ways I think it's going to follow quite nicely from the two things we just heard before. So the kind of research I do tends to be for people who don't have representations. I've done lots of work with litigants in person. I'm doing work on unrepresented defendants. But when I'm thinking about digital justice, I tend to be naturally thinking about the perspective of the people participating in proceedings. So there are lots and lots of things we can talk about as being a potential cost of digital justice. And I thought, actually, the one thing I'd really like to see talked more about that I think really doesn't get enough talk about is the loss of human contact. The cost of digital justice is the loss of human interaction. And this is maybe because it seems like a relatively soft or woolly concern, and it may be because it's something that is quite difficult to articulate in legal discourse. But my argument tonight, hopefully, is that I can persuade you that the loss of human contact is a potentially big problem and has some serious consequences. So, although my focus is on people without representation, I'm going to try and talk about things that I think go beyond their perspective as well. So, 3 points. So the first thing about human contact is it guarantees localness, localicity, local whatever it is, right? The second point about human contact is it might actually do something to enhance evidence quality and fairness. And my third point about human contact is it ensures potentially at least some kind of commitment to equality of justice. So the first point about the local is the very obvious one, that if you have human contact, you have local processes, you have people going somewhere and meeting one another, which means you have to have courts. And as I'm sure many of you are aware, we're having huge closures of courts. We've lost about 50% of magistrates' courts in the last 10 years, I think. More are slated to close. So the online courts are coming at a cost of selling off the public property into private hands. So this loss of places to go has consequences. So there's a researcher called Marie Burton at Middlesex, and she did a really interesting research into when they took the legal aid consultation, they put it via telephone. It went from being a person-to-person contact to the phone contact. And she sort of set about in her research to say, well, what do you lose when you lose this face-to-face interaction? And she came up with sort of 3 key things. Firstly, of course, you lose local knowledge. When you have a place to go, the people you talk to there will know the actual place itself. So they'll be able to have the resources to signpost you to appropriate places. They can tell you, at that time, where you can park, where you can get a coffee, who you should talk to, where the services are to get legal advice from, etc. She also talked about local knowledge in terms of how to do stuff. So someone who has experience will know the kind of local legal culture. This is the person you talk to. This is the way to go about doing those kinds of things. And then she also talked about the really important function of social support. As I'm sure many people here know, people who access the courts or access legal proceedings don't usually just have one problem. They usually have quite a lot of problems and they require lots of other support. So courts provide quite an important function of signposting to those services. So all of these things, if you like, rely on skilled staff. So court closures in the absence of skilled staff is losing these particular things. I would also add, as a litigant in person, for example, you're not someone who is necessarily best placed to be able to adduce the importance or the legal issue in whatever it is you're trying to communicate. So having someone skilled to talk to means that by talking to you in person, rather than filling out a form, they may be able to adduce from you what is relevant. Something can happen in that interaction that couldn't happen via a form or online. So the closure of the courts for me isn't just about pushing people online, it's losing a huge amount of local knowledge that's incredibly important for litigants, and it's just disappearing. So that's my first point. My second point, I'm going to take a swerve into more of Penelope's territory, so video link technology in criminal proceedings and immigration proceedings. So another aspect of digital courts is increasing use of video links. So at the moment it's pretty common in pre-trial hearings in criminal proceedings. It's very common in immigration tribunals. I think in the majority of cases they now use video links. So we already know there are lots of questions about Wi-Fi, reception, etc. You just need to look at Twitter to see about all the problems that are happening with stuff dropping out. But beyond that, I think that there's an unresolved question, something Penelope Gibbs has raised, about what being on video does to how you are perceived by other people. So this was looked at in the 1990s because of the introduction of video link testimony for sexual assault complainants. So they were piloting kind of vulnerable witness protection, saying what happens if you take the person in sexual assault proceedings and get them to testify remotely? What impact will that have on a jury? Like how will they perceive that person? So lots of really interesting work was done, particularly Munro and Ellison did some work in the mid-90s. And the results were kind of mixed, and I think that's kind of par for the course. But one thing that kind of stood out was that there seemed to be a result across a number of studies that people who are going to appear in person were more likely to be believed than those who are appearing via video link. Now, why that is, I think, is an open question. It may be that you have perceptions about screens being inhuman. It may be in sexual assault proceedings you think that if a person's willing to come to court, that is more meaningful. So I don't think we can know why, but I think it can certainly raise a question as to what's happening in terms of perception. And it should make us be a bit concerned about if there's a potential for dehumanisation. Given that it's particularly prominent in immigration proceedings and criminal proceedings, I think we should question again when the participants are more likely to be unrepresented and potentially vulnerable. So there was a bail observation project in 2013 that I think found, what was it, 50% of those in video link were refused bail and 22% were refused bail in person. And then there's a PhD researcher called Jo Hines at Exeter, and she was talking, she's here, I thought that might be you, hi. I was just reading the report that you were giving, you were saying in your research, I felt like you should be saying this, not me. But you, maybe in the Q&A you can expand more on it. But you were talking about the fact that based on your research, it seemed to also show that video link may be less likely to accept bail than in person. And again, you know, we don't know why that is. There are other factors you have to control for, you know, what the issue is, why someone's there. But again, for me, these are really big questions. And then, of course, the other thing is recent research by Emma Roden has found that when someone's on video link, and if they start mucking up, if you like, which is something that defendants may or may not do, the judge has been known more recently to pull the plug, to just kind of cease the link from the courtroom. And that kind of control is, for me, very questionable. You know, I mean, I think there's something else happening there in terms of controlling a defendant that's going beyond what we normally do. Okay, so last point. So this last question about human contact and equality is really about saying who is being put into online courts. So there was a New York Times article last year by a woman called Nellie Bowles, and she talked about the luxurification of human contact and saying, is human contact becoming a luxury good? And I haven't been able to stop thinking about it. And I think it's a good question to ask in the context of digital justice. So we already know that when you determine what's important in the civil courts, you do it on the basis of the value of the claim or the legal importance. If you're a litigant person, you're probably not very good at it. That's unfair. It's a mixed bag, but you may not be very good at adducing that legal importance. What it generally means is that people who are actually acting with more money are more likely to be perceived as having a more important issue. So we've already had this thing where you push people to settle. There's an expectation you shouldn't come to court in the first place. And Linda Mulcahy wrote a really interesting article saying that, going back to Gil's point about open justice, there's a public interest in private dispute resolution. If we keep resolving everything through settlement, our law doesn't develop and we don't get to see what's being done. And it happens disproportionately to those who don't have the access, don't have the representation, don't have the wealth. So for me, the digital justice and those who are going to be pushed online is a kind of aggravation of this kind of tiered justice system. So people who are less likely to have wealth and status are more likely to never actually be able to have human contact with people. So a luxurification, if you like, of human contact. Going back to your point as well, human contact for the wealthy, not for everybody. Now, maybe they don't care about this. And of course, it's true that we have to be able to say, this needs to go to court, we can't take everything to court. Like, I understand that. But the last point I want to make is that, going back to my specific research on litigants in person, one of the biggest issues we have is that of trust in institutions. What is it that facilitates trust? What makes people being willing to accept the judgment of institutions, to participate in them, to have faith in them? And while there isn't a simple answer to that, one of the most kind of influential ideas is this notion of procedural justice, that it isn't about them getting a particular outcome, it's about feeling that they're being listened to in the process, so they understand it, that they're an equal participant. So this digital justice moving to like an online claim, for example, where you're filling in a form, when you're being pushed to settle, when you're not actually having this human interaction, risks really undermining trust even further. And for me, that's a big cost. So to end very similarly to what we've heard before, I'm not suggesting that we can go back, nor that we lived in a utopian system before. I certainly don't think that we did. There are so many problems that we can't deal with all at once, but I think we really need to pay greater attention to what's being lost. And for me, this human connection isn't peripheral, it should be considered centrally. That's it.
Okay, well, we've dealt with a lot of very varied issues and themes, from the logistical to the governance to the pastoral welfare role within the criminal justice system. Penelope, you have the role of discussing. I only ask that you don't shout at Gil.
Actually, I didn't disagree with anything. I literally didn't. I really didn't. There's some kind of nuances to open justice in the criminal courts which we would disagree about, but in general, I didn't disagree with anything at all, and I do believe in the principle of open justice. So I just want to outline what is happening in the criminal courts with this digital court reform programme. So going back a few years when this was started in 2016, I have no doubt myself this is about money. This is about saving money for the court system. The narrative that the court service and Ministry of Justice and even the judiciary say is not about saving money. They'll say it's all about, sparkly access to justice. But if you think about saving for money, that's why they're doing it. It kind of makes more sense. So the idea is that what is really costly is the physical court hearing. To have a court building, to have people in it, to get people there, all that kind of stuff, that is expensive. So their overall idea is to reduce the physical court hearing as much as possible in all the different jurisdictions. Because then that means that they can save all those kind of service costs, but also they can close the buildings. And they've closed a lot of the buildings already, and they have plans to close a huge number more of the buildings. Because what they would say is, we don't need them because we're not going to have the physical court hearings. Ironically, in the criminal courts, there are hardly any, there are many, many less court hearings because prosecutions have gone down. So unfortunately, they're looking, their figures are looking quite right there. So the idea is you push proceedings either online or in fact by post, or you put them on video. So just to outline what the video bit means if you're going to close a court, their kind of blue skies idea is already you've got people coming in on video from prisons and from police stations into criminal courts. And this is, here I'm talking about defendants. You also get in higher courts, in Crown courts, witnesses on video sometimes, or pre-trial cross-examination on video. That saves a bit of money, not really the witnesses bit, but the defendant's one, because you save on kind of transport costs and the court cells, looking after people in the court cells. But the big money obviously comes by not having the hearing in the court. So their big idea on video is to have all video hearings. So this involves having every single party in a criminal case on a different video. So I don't know if any of you have done group Skype calls. That's what they're talking about. Exactly that for criminal court proceedings. So you'd probably have 6 frames, wouldn't you? For the judge, the prosecution, the defence, the defendant, possibly the clerk, etc., or a practitioner, and they'll all be on the one screen. And the lawyer is likely to be in a different place from the defendant. They are working on that or they're working towards that, they claim still, via a pilot programme in Chatham Magistrates Court, where they have the most advanced kind of video technology from the police station into the court. But that is, and they'd like to introduce that across civil as well. So starting in criminal, but across civil too, these all video courts, and they've also done it for tax tribunal hearings, for which there is a small-scale process evaluation involving a very, very small number of people, which they call a success on the basis of a very, very small number of people. So that is the future in terms of one end of closing the courts. The other is online. And I just want to talk very briefly about one aspect of criminal law online, which illustrates a lot of the problems that we're talking about, which is that the majority of criminal cases in England and Wales are now not heard in courts at all. They are done through a postal process. So that's numerically the most cases. So here we're talking about TV license, not paying your fare, things like that. There's huge numbers in those cases. And what they've done is that started actually before the Digital Court Reform Programme. But for them, this is the future, because those cases are no longer held in court. And what happens is they send somebody their charge in the post. That person is supposed to fill in the form and then respond either on the form by post, or they can go online and start pleading guilty or not guilty there. Obviously, if they plead not guilty, they do get into court, which is good. But if they plead guilty, which is the majority of cases, they will go through this online or postal process where the case is heard. I mean, it kind of is a bit meaningless, in a closed court by a single magistrate, completely closed. And basically it's a tick box exercise where everybody who pleads guilty without mitigation gets X fine, everybody who kind of didn't respond gets Y fine, and so on. It's just conveyor belt justice. And then people get, sorry?
It doesn't differ from the old system 40 years ago. It was just all done by post. It was exactly the same.
But were the majority of criminal cases done through that process then?
All the trivial cases that were done by post, the driving offences, exactly what you just described happened to the magistrates courts. I know, I watched.
Right, okay. Well, I think the volume has increased, and they want to put more and more cases through this online process. And they also want to get rid of the middle bit, which is that the magistrate sitting there making some kind of judgment. But what's happened is since they've increased the number of cases which go through this process, the proportion of people who don't plead at all, guilty or not guilty, has increased from 50 to 75%. So it is, I think, the increased number doing it that way. So it comes back to the human contact and interaction thing, that if somebody receives something in the post, do they receive it? I mean, it's a very impersonal thing. They may not even get what was supposedly sent in the post. Who knows? Because it's not done in any kind of recorded way. And then also nobody's there to help them through the form, or just to say, oh, I think you better do it. They might, ignore it, whatever. People do that to bills. But on the open justice point, I think this is quite interesting. It is a closed process. You're saying it used to be like that. It still is. A greater volume is going through that way. But under pressure from campaigners for open justice and saying that this process is too closed, they've now got a new process whereby actually you can see that court list online and you can download it. So it's kind of weird. You can't do the same for a magistrates court case, but you can do for a TV licensing case. And you can download that whole list any day, just the days list. And then you can find out what happened by phoning some number. But my concern about that goes back to Article 8. If 2/3 of those people haven't pleaded not guilty or not guilty, then we don't know that they've been charged with a crime. And there's something to me which is not just about publishing the name of a whole list of names among which 2/3 might not have actually know that they've been charged with that crime. So you're publicising somebody being charged without them necessarily knowing they've been charged. And hardly anybody looks at the list, but in theory, I think that's a problem. So they're going towards, and they have not met the needs of open justice, either with this process, because I would say you've got to let people know that they're charged with a crime before you publicise the name, or with the all video process. Because obviously if it's an all video process, how on earth do you get public or media access to that process? And I keep reading statements from them where they just go, that I'm not convinced they'll ever get to the all video process, so in which case we won't have to cross that bridge. But even so, if you go to a court and you see either the witness or the defendant on video, I would say it's still not proper open justice. And I keep reading really important cases where actually the sentencing is happening on video. And that is clearly, they're not giving evidence, but on the other hand, you would have thought it's quite an important bit of the process for both the defendant and the victim in the case. But that, and those kind of video links are just increasing willy-nilly without any of us knowing the numbers. So I'll stop there.
And the point that you can't observe that process, so you can't go through a dummy version of the online plea, I think you've said to me before.
Yeah, that's one thing that really gets me. The single justice procedure, the one that's by post, you can get a copy of the postal form if you really try, though it's difficult. But the online process, none of us can access it. I've seen it twice now on roadshow events by the HMCTS, where they've let me sit down and I've made the same complaint about the legality of the process. There's bits on it which I think are dodgy, twice, and nothing changed between the two things, and nobody can go on and there's no reason why they can't let us see what it looks like.
Very quickly, I'd like to follow up on one of the points that you raised at the end, Jude, in terms of oversight and improving accountability of the current digital reform project as it's going forward, and to revert it back to each of you. So let's say the MOJ see this seminar, because it will be made accessible afterwards, because we're very much advocates of open justice and transparency at the Institute for Advanced Legal Studies. And it's decided that this is a really useful and potentially very hopeful way in which to address a lot of these issues is the appointment of an independent reviewer of the digital reform project. So if each of you were brought in for a consultation, if it was one recommendation, just one, that each of you could make in terms of how the current process could be improved, or where certain steps should just be halted, stopped in their tracks immediately, or where certain areas should be prioritised, what areas would you say immediately demand attention, or which areas would you say should immediately be cancelled, taken off the project completely? Jude, we'll start with you.
Oh my goodness, sorry. That's not fair. It just came up
This was your excellent suggestion to begin with.
Oh, I'm torn. I mean, one point I thought that we haven't drawn out quite yet is the sort of the methodology of the process of courts reform, which, you know, I'm hijacking and borrowing Penelope's things that she's written about previously, but about the agile methodology where you're just doing it bit by bit, this bite-sized approach, which makes it more manageable and quite practical, but it does mean that you're sort of introducing this particular process before it's been fully tested, and I think, I can't remember the way that Penelope's described it, but it's sort of almost an upside down process where some of the underlying research hasn't been done before the thing is introduced, which could obviously have quite serious side effects.
So you don't think the project is evidence-based?
Yeah, so I think it's coming back to that point that my ask about independent research. So I think the process, we need a better sort of methodology or process for the introduction of a particular innovation before it just happens. And so there's small examples that have already been raised here tonight where things have just been introduced, like Penelope mentioned, the creation of the online list for the single justice procedure names, which is just something that I think they could have asked people about, and we could have raised concerns that this was actually at odds with other sort of courts practice, or thought about some different perspectives, and actually just question whether that should be happening in that way or not. So I don't know if that's there should be some requirement for a sort of research stage that isn't just in-house and kind of closed and not open for academic and public scrutiny, I think, if that answers your question.
So do you think the consultation should be ongoing, or do you think there should be a general consultation now, after the fact? I mean, the project's already been launched.
Yeah. I mean, it has to be an ongoing process where you're constantly reflecting on the impact of what you've already done and the impact and the potential implications of what you might introduce. But I think that there has to be some kind of standard that enforces that sort of research stage before potentially quite impactful things are introduced.
And the role, for instance, of the independent reviewer of the project is someone then who will constantly be a hub or a reference point for these kinds of consultations in terms of following up with particular departments or units, say, of the MOJ or different parts of the court system.
I think so, yeah. So if there was a particular user group where you felt that their voices hadn't been heard or these things had been overlooked, like some of the concerns that have already been raised here tonight, they would be sort of forced to respond on those points.
Gil?
I mean, I've just been jotting down I mean, from the journalistic perspective, the hardest thing at the moment is finding out information about anything in any sort of logical, consistent way. So, and picking up on Kate's point, you know, if there's going to be an issue about delocalisation or dehumanisation, it's also going to affect local journalists. You know, again, those sort of the training of going down to the courts and sitting there and seeing that and knowing all that will disappear if there are no local courts. So you know, if it's difficult enough now to find out about cases, how are you going to find out whether cases are in your area with your people about issues involving your you know, where you come from? So for me, sort of, there's a discussion to have which I'm not aware of, which Penelope and I have discussed over years, and Jude as well, on, you know, naming, when you name, what you name, how you name, and there's clearly a balance which has shifted over the years I've been in the media, from when, you know, 20, 30 years ago people were named on arrest routinely, the police named on arrest. That's shifted now, so you don't get named on arrest by the police. They will name on charge, because charge is considered to be the process whereby the state has the evidence to think that it can bring you, whereas arrest is a much lower threshold. And from the media's perspective, you know, they still would want to name people on arrest, but there is a balance to be had in that process. And whether, the whole way things are listed shifts from, in the early stages, information about the sort of case it is, the sort of area it comes to, what sort of case, to at a later stage names being added to it, so that that open justice issue around the naming is still dealt with. But again, I'm not aware there's been any sort of discussion around the nuances of that, so that people get the necessary information. Because with a lot of cases, there are some cases and names that journalists will be looking out for, but also they're looking for the sort of cases that are going on. Whether it's a terrorism trial or whatever it is. There is no indication of that in most instances on listing. And quite often it's a series of initials anyway, with nothing at all. So there, for me, there's a whole thing to be done around that, around getting the right balance, so that you recognise the open justice issues, but you also recognise the Article 10 and the Article 8 issues that go with that.
So you think the way the current system is being pushed forward, it's exacerbating that ad hoc system of public access, particularly for journalists, the public as well, but particularly for journalists.
The public, yes, who have the same rights, if not, the absolute right, but the reality is that that's reflected by the media in a lot of cases. But yeah, it's terrible now, and I hear nothing that makes me think it's going to get any better. And if what Penelope says about the single magistrate process is right, then people's names are being put out in context of criminal proceedings with no context whatsoever, and that can't be right or fair either.
So you'd want to see access to documents, for instance, be prioritised within the project, because
I think there's a difference. That this is listing information, which under the criminal procedure rules is supposed to be listing information. You're supposed to be able to get it from the courts, but journalists can turn up in court, they can phone the courts, and they get completely different ideas. That's separate from getting the underlying evidential information that you may need by way of witness statements or documents that are referred to in court, in order to understand a lot of what's going on and do the fair and accurate court reporting. So that's a separate issue to this.
So that ties back into Jude's point again then about an evidence-based approach where you have identified the current gaps in the system with regard to Article 6 ECHR rights, which also tie in then to the Article 8 ECHR right to respect for private life that you also mentioned as well.
Yeah, I just get the impression...
So they would be flagged and then addressed.
Yeah, I just get the impression, there's sort of lip service done to the Article 6, Article 10, privacy, all those issues. Yes, we know that that's a problem, don't worry, we're dealing with it, but the practicalities of it and how it manifests itself day to day, from the individual in the system to the journalist looking for the system to the public wanting to know more about it, I'm not aware, and I'm not heavily engaged in it day to day, but of anything being done realistically to say, well, there's a problem there, or there's not a problem there, or we need to address that.
Without that external scrutiny or the external input from consultations, you're not going to have those particular priorities as top billing. You're going to have internal priorities such as managing the cost
saving.
Cost saving.
Well, and private interest. Sorry, just button in. Sorry, I don't want to talk but when we've moved over to digital systems, sometimes the old legacy problems go with it. So in the Royal Courts of Justice, they've introduced in the Queen's Bench electronic filing, and so you can access these public documents electronically for exactly the same cost as when it was the paper-based photocopies. And I just don't understand the logic of that at all. It's a Thomson Reuters operated service. There's obviously a profit being made, but just things like that are happening without, like you said, considering the practical questions.
Kate?
Can I be an abolitionist about the whole thing?
Absolutely.
I really am not a Luddite, but I think Penelope's point stands that this has always been about saving money, and I think to misrecognise it as having to do with expanding access, that is just something they've retrospectively added on. The sale of public assets is a form of asset stripping, and I think this is a really serious thing that's happening. So if I had it my way, if I was actually able to influence things, I would say that the purpose of having digital justice should be as something that can complement and extend the scope of a strong local court system. You need a local court system because courts provide a complex social function. They aren't just places where people resolve disputes, and they never have been. And I think lack of recognition of that is going to cause a lot of damage. Like I said, there's lots of loss of knowledge. So technology, I think, can work for facilitating greater access, for having greater flexibility. I'm very open to those possibilities, but it needs to be an add-on, I think, to a court system that thrives in a local capacity. And I accept that that ship has sailed, and I think there's something about, the sheer ambition of the court modernisation programme. 10 years ago, I was temping as a medical secretary and I was working at Barts Hospital. And the NHS at the time, they were talking about introducing this tech that would allow everything to go online. At the time, everything still, and I think it still does, largely functions by fax machine. And when I was working there, the systems went down, and for I think 4 days, no one could access any records. And my job went from being a secretary to being a runner, and I was running from department to department with sheafs of documents to sort of pass them from place to place. And the absurdity of it was the fact that the NHS is so chronically underfunded and the staff is so underskilled in that respect because they're de-skilling and paying them less. The idea of them being like the centre of IT development was absurd, and I think the same thing relates to HMCTS. I mean, this is not a place where they've invested heavily in those kinds of resources. The kind of tech they're talking about relies on seamless, high-level efficiency and monitoring, and they simply don't have any evidence behind them that they are going to support that financially. So I think that you need to invest in the justice system. That's a pretty big starting point. So the ambitiousness of the court modernisation project to me is at odds with its known functioning when it comes to things in the matter of tech. I would say there's a disjuncture for me as well. So I'm sorry, I probably wouldn't be consulted on these policy things for these reasons. That would be my perspective.
Call the whole thing off.
Call the whole thing off. Yeah, I know that you can't, and I think there are values to online courts and platforms to some extent, but it's been done in a way that has not paid any attention to what matters, and I think we're losing it, and I think that's terrible.
So mistakes of the past with regard to other sectors like the NHS, you think are just being repeated here?
Well, I think that, when I talked about this luxurification of human contact, it's certainly not just happening in the courts. I think a lack of accountability and a lack of a person to talk to is just a thing now, you don't get to talk to anybody anymore. It's a method, in a way, of diffusing accountability if you don't have a single person that you can actually communicate with, whether it's for any kind of product or service or, when I lost my permanent residency card coming back into the country a few years ago and couldn't get anyone to talk to, no one would talk to, I just refer you to the website. I think it is not just the courts that are doing that, but I think that there are ramifications for that, and I think it's a problem.
I think something that hasn't been touched on yet, and I completely appreciate it in terms of the fact that we're thinking of this from an open access perspective, is also the internal implications that you have of streamlining and getting rid of people, and how that's actually going to affect the delivery of justice, particularly the judiciary. So clerks, anyone that they have in terms of tip staff, there's this focus then that this will also become centralised in terms of getting rid of people. So any extrajudicial work that judges currently do in terms of sitting on commissions, in terms of appointing a judge to be the independent reviewer of terrorism powers or to be an independent reviewer of this kind of project, that time will also be taken up because they're not going to have that administrative support. So there are lots of knock-on effects to this that don't seem to have been comprehensively mapped out as yet.
Well, also, I think, I sit as a part-time employment tribunal judge, so I see some of this in action. And I had a case where someone was just deeply distressed by the whole thing. She made it to the court, but lasted 10 minutes in the hearing, and she couldn't cope. And in the end, she couldn't leave the room. An ambulance had to be called, and you can sort of see. If you take away that, at least there were people there, very concerned clerks, who had dealt with these things from time to time and did their best to reassure her, and phoned her son to come in and sit with her, and all of that will go, and there will be you'll end up with people sitting in their rooms, having no support at all, no communication, because nobody's going to see it happening. And all of that, I think, feeds into to this, and these, you know, the clerks and the people who are there, who are being downgraded all the time and being expected to do, because it's all becoming much more routine. So the sorts of things that made it a bit more of an interesting job are being taken out of it. All of that, and they're all important parts of the access to justice, because it's not just sort of, you know, straight into the court system and get you and come out again. There is a wider thing to it. So all of that, I think, you know, is worrying. And again, I'm not sure that aspect has been looked at by the MOJ at all.
So you don't just have the stripping away of buildings as an infrastructure, like was mentioned by you earlier, Penelope. You've got the stripping back of individuals as well, or at least the humanity from the legal system.
They are cutting staff.
They are
significant numbers, yeah, because they would say if you cut a physical court hearing, then you don't need the staff. So they are cutting them back hugely. I would. They're very good in their narrative of mixing up digital basically digital filing, the behind the scenes stuff, and digital involving individual people who may be witnesses or plaintiffs or defendants. And to me, I would stop them muddling them up, because I don't think any of us really object to really good digital filing systems. And when they criticise people like myself, they'll always imply that I don't want, you know, great digital files. But of course not. I don't, you know, of course you need them efficiently done and so on. But it's when it comes to the people. So I would halt the whole of the programme, which is about, you know, real people.
Isn't that everything?
No, there's these common platform and stuff like that, which is behind the scenes. There's huge programmes which are about digitising information, files, listings, etc. I mean, I don't know what proportion of the programme it is, but they are very costly bits of the programme.
I mean, also, again, I don't know whether there's, you know, one of the things that sort of has also sort of underpinned some of this, and maybe it underpins some of the single justice stuff, is that there's a sort of implied consent that you know, so you have your options, you can agree, you can do it in the post, you can do it by this, so that, you know, it's sort of trying to give it a validity around consent, which actually, it's not really proper consent, is it? It's not informed consent in the way that most lawyers would be happy with. And all of that seems to be sort of slightly swept under the cover. So it's very different from having a spat on eBay over something you bought and saying, yes, I'll go through your mechanical process for my, you know, my 50 quid, whatever it is, and I'll accept that verdict. To doing that sort of thing in the criminal justice system particularly, or in the family courts, which is probably going to be way behind in that sort of thing, you know, because they're struggling with other things.
Those judges have put their foot down. In the family courts, they're basically saying, apart from divorce, we're not going to do online or video, as far as I can work out.
Well, I think there are things in the pipeline now, aren't there?
Like what?
Don't have the detail to hand, but there was some, I don't know, hints of things that are coming.
Yeah, but compared to the rest, I think that they're not supporters of putting individuals out of the court.
Or are they more explicit protesters of the changes?
They're not explicit. None of the senior judiciary would explicitly do it. But if you read the plans, it seems to be slightly different to me. And the people who've been the proponents of it have been Lord Justice Briggs, who is civil and criminal lawyers, and Lord Ryder, who is now Senior President of Tribunals. Exactly. So you just, you know, as a watcher of the language, I'm not convinced the family ones are with the programme.